rise. Court of Appeals Division 1 is now in session.
Good afternoon. Please be seated. All right. Good afternoon. Today is August 13th, 2024. This is the time set for oral argument in our case number CV24 545 Lane et al. Versus City of Scottsdale et al. Out of respect for counsel and to avoid any embarrassment for anyone in attendance in the courtroom, please make sure your cell phone is on silent. Though Judge Sam Thema is not present in the courtroom today, he is watching argument remotely and participated in conference prior to argument. Each side is allocated 20 minutes for oral argument, although you are not required to use all your time. If appellant wishes to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium. The clock on the podium reflects your total remaining minutes. Please keep in mind that we have read the briefs, studied the record, and discussed the case in conference, so please keep that in mind as you present your case. You may proceed.
Thank you. Thank you, Your Honor. Scott Day Freeman and my colleague Adam Shelton with Goldwater Institute on behalf of the appellants. And if it may please the court, this appeal is about the language the City of Scottsdale approved regarding their desire to levy an additional sales tax beginning next July 1 of 2025. It's not about the merits of the tax. It's not about what the tax money should or should not be spent on at all. It's about the words on the page. The approved language... I
appreciate that, counsel. I just want to jump right in. Are we under 19101? Is that what your challenge is under?
It's under 19101, yes, which would be the statute. Malera was based on 19102, which dealt with initiative petitions. This obviously is a governmental referral. It is a type of referendum. It is effectively an initiative whereby the government is the sponsor.
But 19101 deals with what needs to be in a petition when the people refer something the government has passed to the ballot. I'm struggling with how the language in 19101A applies here when it talks about referring to the people by referendum petition and then gives the form of the petition. It seems like we're in 19125 territory here, not 19101.
I think I hadn't quite finished, but I think we're under both because we're dealing both with the description of the ballot proposal as the government would describe it, and with respect to the specific ballot language itself, the 47 words.
Right, but the description is the 50-word description that's talked about in 19125, not the 200-word description. Correct. That's laid out in 19101. Isn't that right?
Correct. But they both come into play, though, Your Honor, because they've approved a tagline, which is the 47 words. That's the question that the voters will see and answer when they vote. That is misleading. The whole package is misleading. The entire descriptive title, the yes-no explanations that the city has come up with, that would appear, perhaps some of that would appear on the ballot, but it would also appear at the polling place as part of the sample ballot.
Do we know at this point what is going to be on the ballot and what isn't? I was a little confused about that in the brief. Maybe we don't because the county chooses whether to go with the shorter form or the longer form, and we haven't gotten there yet.
Correct.
Okay.
We don't know that. What we know is what the city has represented, which is the tagline text.
It's going to be one of the two that were attached as exhibits to the resolution.
It would be the option B, which was approved.
Okay.
Right. Is that what you're referring to?
Well, I thought there were the two, I guess, I don't know if they're both exhibits, but the two documents are a longer form one that was approved and a shorter one that was approved.
There's one that says descriptive title, and then the other one says tagline language.
And I think which one is ultimately used depends on how much space we have on the ballot in November.
Well, the tagline would be used. It's whether the additional language could also be included in the ballot.
Right, whether the descriptive title.
That is what the city represented at the time they approved this language.
Right.
So the language that they approved, both for the tagline and for the entire package, does not comply with the law. Through its ballot language, the city is trying to convince voters that they're reducing their taxes when in fact if they approve the ballot measure, they will be increasing them. That is a bait and switch. That is something that is per se misleading. It is misleading under Malera.
Just another preliminary question about procedure. Was the trial on the merits consolidated with the PI proceedings here? In other words, if the court just determined everything, and so for us, I think that determines whether we're looking at a preliminary injunction versus a permanent injunction. I think we're looking at a permanent injunction, right?
Correct, Your Honor. And the trial court dismissed on the city's motion to dismiss, but the motions were two sides of the same coin. They were arguing legal issues. Either it's misleading under Malera or it's not. The parties agree that Malera set the standard here for us.
If I think this is a 125 case, isn't the North Star decision that I look to quality education? Not necessarily Malera?
Well, Malera synthesized all those cases, but I think you would look to both. The quality education case was a little different. It is not really on all fours here. That dealt with the Secretary of State choosing language. Here we had the city clerk, who was effectively acting as the Secretary of State, proposing two different versions, and the city council itself decided. They were the sponsors. They selected the language, which is a little different than the Secretary of State writing the language and then being challenged.
So I guess you would say then that Malera applies because in Malera you have a party who's interested in having the thing passed that is putting forward the language versus a pure 125 case where you have the Secretary of State and the AG, who at least in theory are supposed to be divorced from the folks that are actually trying to get the legislation through.
Correct, and they're supposed to proceed with some measure of neutrality. And so, yes, that would be the case. They're trying to get and that is an additional reason why the ballot language that was approved is misleading. And it's something that we face when the government is the sponsor, where we wouldn't necessarily face when we have private citizens being a sponsor. Malera cites the cases that synthesized, noting that there's maybe a little latitude with petitions for initiatives, and that's, I think, to respect the free speech rights of the people bringing those matters. But here we're not dealing with citizens, we're dealing with the government speaking, and the government speech doesn't have the same right to freely speak as we as citizens do. In fact, public policy of the state limits the speech of government, and in this case it limits the speeches of cities pursuant to ARS 9-500.14, which prevents the city from using any of its resources to try to influence the outcome of the election in any manner. And certainly the way they've constructed this ballot language, it's designed to lead voters to think that they'll be reducing their taxes if they pass it, and that is misleading. That's trying to lead them to a certain result. It's trying to highlight some benefit of passing it, a benefit that doesn't really exist, and that violates Arizona public policy. The citizens have a right to expect that their government, when it speaks, is not going to try to lead them by the nose to some result, and when it does, it misleads.
So are you asking us to establish a different standard for, citizens who are, putting forth an initiative versus governments who are?
No, we should follow Malera, but Malera wasn't exclusive as to what would be misleading. It's misleading if it presents objectively false information. We believe that the ballot language does contain objectively false information, and for the reasons we've hammered home in the papers, that it omits material facts, that it requires citizens to sort of puzzle piece together all these pieces and still won't understand fully what's going on.
So I'm glad that you bring that up, because Judge Thumma did have a question that he wanted us to ask, and that is, what should they have said? I realize that, what the case law says about us making a determination, but what should they have said to make this within the law?
I'm going to answer that question, but before I do, I'm going to say it's not really our job or place to say what the city should have done or should have said. There's probably a myriad of ways.
And it's not our job either, right?
Correct. But it's the court's job to step in and say, if you haven't followed the proper procedure and have put something forward that is misleading, to disqualify it. And that is within your authority to do that.
So if you would have said something, what do you think it should have said? How would it have passed muster?
playing the hypothetical game, if the land acquisition tax, the 0.2% sales tax rate that the voters approved in 1995, that will run its full course all 30 years, do everything it set out to do, ostensibly, unaltered, unmolested in any way. Its rate will remain the same the entire term, and it will expire by its own terms, irrespective of any, not requiring any vote of the council or the people. It ends. It is as if the line on the graph just ends. It doesn't go to zero technically, although that's effectively what happens. The line just ends. It is the new tax is being implemented after that. Whether it's on July 1st or July 2nd, doesn't really matter. They don't overlap. It happens later. So in that sense, that tax is completely irrelevant. It is a sideshow designed to get the voters to think they're getting something for nothing. All the city really needed to say was, shall the city be authorized to impose a 0.1% sales tax rate beginning on July 1st or whenever, 2025, expiring 30 years later for the following dedicated purposes, period. That's all they needed to say. If they wanted to explain all the other aspects of the city sales tax and all the different special taxes that have been imposed and will expire, some will expire, the next one will expire in 2020, they were free to lay out a very simple fact sheet that lays out those facts. But in terms of what ballot language they could have used, there's an example for you.
So one definition of replace is to put something new in the place of. If using that definition, how is replace misleading, false or misleading here?
Well, there is nothing that is being replaced because this one will have expired. Nothing will be there on July 1st. There is the current tax, the tagline says, Scottsdale's current 0.2% transaction privilege tax, sales tax rate, expiring June 30th, 2025, be replaced and reduced. The current tax will not be replaced and reduced. It will not be there. You have to read later to the yes/no explanations to find out that, well, the new tax is going to be imposed. Not now. You would reasonably believe that it's being, if you vote in favor of it, the new tax goes into effect now and we get these wonderful things outlined. But it won't. It will go into effect after this tax expires. So that is misleading. Nothing is being replaced. Nothing is being reduced. That tax, 0.2% sales tax rate, will be in effect full at 0.2% for all 30 years. It will never be reduced.
If the tax being proposed was to raise additional funds for an additional amount of time to acquire land for the Sonoran Preserve, would you still have a problem with replace and reduce?
Yes, because I'd have to think about that, but these are very different purpose taxes here. One is strictly for land acquisition, the other is to provide ongoing services. If they were to simply say, we're extending the term, they could have done that. It's set to expire on June 30th, we're going to extend it for another.
So could they say reduce? Could they say extend and reduce? If it was going from 0.20% to 0.15%, but was being used to acquire land for the Sonoran Preserve?
The current tax term that is set to expire on June 30th be extended another 10 years at 0.1%.
Or would you say they can't even say reduce in that situation because the current tax expires on June 30th of 2025 and the new tax comes into place in July 1, so it's still not reducing?
That is correct, and it is imposing a new tax, and that needs to be clear to the voters.
Even if it's for the same purpose, it's a new tax?
Yes, because the previous tax that the voters approved expires. It goes away.
If in Judge Catlett's question, you're just extending the deadline. So the deadline is set to expire on June 30th of 2025. The voters prior to that expiration say that we're going to extend this and we're going to reduce it at the same time. How is that having a new tax at that point when it's for the same purpose?
It would still be a new tax because the current tax will have expired. I guess if the expiration date was as effective upon the passage in the canvass, in the passage by a qualified majority, that might be a different situation. Then the current tax then is amended to an extended term, and the rate is variable or something like that.
Right, so
that would be,
even if the city code, or even if the resolution the council passes just says the city code shall be amended by striking June 30th, 2025, and putting in June 30th, 2055, it couldn't use reduce?
as long as it didn't mislead voters into thinking that this wasn't a new tax being imposed, because that's what would be happening.
Okay.
I don't know exactly what specific words should be, and I'd have to think about it. But it would need to be clear and not mislead voters into thinking this is inevitable, taxation is inevitable, so I might as well take this deal where it's going to go, they're telling me my taxes are going to go down, and not sort of highlight the fact that if you vote no, my taxes are going to effectively go down.
How were the funds used for acquisition of land obtained over the last 29 years? Were those segregated in a different account?
I would
Or were
assume
those general fund?
those should have
The
been,
new one's general fund. It's not entirely clear to me, based on the record, how the current funds are, if those are going into the general fund and they're earmarked, or if there's some sort of separate segregation of those funds.
I don't know what the city does on its end accounting-wise, but what the voters approved was very specific. It was 0.2% sales tax rate imposed to acquire land. So when those taxes are collected, I would think the city would have accounted for that and make sure that the money coming out of that tax was put in a bucket or an account from which they would use to purchase land.
I want to go back to a question about the lawmaking aspect of this. I think there's been a lot said, and the case law talks a lot about we should divert issues to the voters and not interfere. We're a separate branch of government. We don't do legislation here, so we should be careful about interfering in the legislative process, which this is. So I wonder if you could speak about that a little bit and how what you're asking us to do and kick this off the ballot, if it's on a line, say, let's just hypothetical, if it's a line, should we defer to the voters and just say this should just go to the voters, or should we defer and say if it's a line, then we should strike it?
The court should strike it. It's the court's job to keep things that are misleading off the ballot. That's the court's duty. The court's not going to be telling the city of Scottsdale what it should do. It's not going to be telling it what language to pick. It's just going to say the language you did select is misleading under the law. You need to go back to the drawing board, and the city can do that.
Okay, thank you.
I wanted to highlight one other aspect of the tagline text that perhaps wasn't brought full to bear in our papers. And that is, the tagline text says the current 0.2% transaction and the sales tax rate expiring on June 30th, 2025 be replaced and reduced, that language, to 0.15 for 30 years solely to fund improvements, maintenance, and increased police and fire protection. That's the purposes of this new text. Now, what's interesting about the language they chose is where they put the word increased, because they did not put it at the beginning of that list. They put it in front of police and fire, which would lead voters to believe that if we don't vote for this, we're not going to have maintenance and improvements to our parks. And yet, undoubtedly, the city has been maintaining and improving its parks for the past 30 years. You would not get that impression from reading the tagline text. If there are no further questions, I'd like to reserve their last 2 minutes.
I'm actually going to give both parties 5 more minutes because I have another question that I want to ask. I want to look at how would you define a reasonable person? Because part of what we're looking at is what a reasonable person would interpret this language to be. How do you define a reasonable person?
Not lawyers reading papers like we've been doing. Everyone in this room and behind me are probably very dialed into this. I think the reasonable person here is going to be the reasonable voter, someone who goes in perhaps on election day and just sees the ballot, what's on the ballot, and makes decisions based upon that. So the city needs to be, and anyone putting anything on the ballot needs to be very careful about the language.
Okay, but that doesn't define what a reasonable person is. How do we define what a reasonable person is?
It would be the reasonable person standard applied, I guess, in any other context, in a tort context perhaps. The average person that's going to be viewing this, not someone with specialized knowledge, not a lawyer, not a city council person, not a proponent of increased taxes to do these things for the city. The average voter who's going to pay attention perhaps on election day and go in and read the ballot and make a decision based on the words put in front of them.
Is that a question that should have been addressed at the trial court as to what the reasonable person standard is?
No, because I think the court in Malera is trying to say that it's an objective person standard to sort of get away from that. And the court even noted expert testimony isn't typically going to be required here. And that's to avoid, you can imagine, we'd have to go do hire experts and do polling data and maybe bring in panels of people and quiz them on different language. That would take a long time, and we'd never be able to get through these challenges in an expedited fashion like we've done here.
Do you think we should assume the reasonable voter reviews the question, things like the question and answer document that the city released?
That's a good question. I think they're going to, unquestionably, they're going to review what's on the ballot in front of them. Whether they take that next step,
I do not typically.
I'm not sure. Yeah.
Those things. So I don't.
Well, I mean, personally, I may be put on inquiry notice on certain things, but I'm like you, I suppose, and I do not as well.
Thank you.
Thank you, Your Honor.
Mr. Morgan?
Thank you. May it please the court. My name's Craig Morgan. I'm with Sherman and Howard. With me are my colleagues Shana Stewart and Jake Rapp. We represent the city. I want to talk about a more relaxed standard that should be employed to allow a city to refer a measure to voters. Now, you may be asking yourself, you may be wondering, what is that more relaxed standard? Where does it come from and how does it apply here? Well, that more relaxed standard doesn't actually exist. So it can't apply here. And if I asked you to apply one here, I'd be asking you to make up a new standard. And that's exactly what the plaintiffs are asking you to do. They're asking you to just make up a new standard. And I think that, I would hope that inside at least you shudder just a bit thinking about making up the law as you sit in this court. And I hope that that feeling's the reason why you decide to affirm. We have one standard here, and there's no need for this court to deviate from it. And you can only challenge this measure on two grounds, okay? One is if the sponsor omitted a principal provision of the measure, regardless of whether it's misleading, confusing, or unfair. It doesn't mean all provisions. It means only the most important, consequential, and primary features.
But that standard comes in under the case law dealing with 19101, doesn't
Agreed.
it?
Yes.
So you're okay with us treating this like a 19101 case?
I'm okay with you treating it as a 19101 case. I'm okay with you treating it as a 125 case because I think we meet the standard in both situations. I'm just simply, for the city, responding to the briefs that were filed.
But we may have future cases dealing with similar issues, and so I'd like to provide some guidance to folks other than the parties that are before us in this case as to what standard applies when we're dealing with a city council referral
Sure.
versus a referendum or an initiative. So I guess if writing on a blank slate, if you were me, what standard would you use? Quality education?
I think quality education and Malera both are a good start. Let me explain why. They both require you, at the end of the day, to state the principal provisions, right? I mean, that's what the statute says. And I intellectually was having a hard time just completely telling this court, ignore Malera, because, that reasoning was being applied to that sort of directive under the statute, right? And so I do think Malera is helpful. I also don't know that I view Malera and quality education mutually exclusive. I think at the end of the day, if you look at this, you look at it and say, okay, does it communicate objectively false or misleading information? And it doesn't. It just doesn't. It just doesn't. And I think that that standard is an appropriate standard, and I think that the court's reasoning in Malera is sound when you're interpreting the principal provision part of the statute.
I'm not sure that quality education has the principal provision language, and I think the reason it doesn't is that the ballot description is limited to 50 words in that context, whereas under 19101, we used to have a 100-word limit. Now we have a 200-word limit, which leaves a little more breathing room for including all the principal provisions.
I agree. I agree, Your Honor. I do agree. I will tell you that, again, my rationale trying to reconcile 19125 with Malera was simply, I read 19125D, and it does say the descriptive title anyway, shall contain a summary of the principal provisions of the measure. And my understanding is that they're challenging that and everything else. So I'm trying to sort of touch all the bases. I wanted to make sure that the court understands from our perspective, under either standard, we're fine. We're absolutely fine.
So, Mr. Morgan, I understand what you're saying is that you're fine and it's clear. I want to ask the question, throughout your briefing, you refer to this as the fractional tax rate, and I think you explain, what that means. But in the ballot language, you use transaction privilege and use tax, and you never use that in your brief. But yet we're supposed to understand that voters understand what's being used when you're not using the same terms in your briefs. And
the question, I want to make sure I understand.
I'm just trying to understand.
Help you understand why we did that?
If the language is clear on the ballot, then why in your briefs are you not using the same language that's in the ballot?
Because remember the ballot, it says it's the transaction privilege and use tax rate, okay? It's not the tax. The tax is composed of a lot of different components. Right now, what we're talking about is part of the rate. So I'm trying to emphasize
the fact. But isn't the rate 1.75?
The actual transaction and privilege use tax overall rate is one thing. But the tax, I should say, the grand tax. Here, though, we're talking about a portion of the transaction privilege and use tax. We call it the sales tax. A portion of the sales tax.
Again, I'm going to ask, how is a voter supposed to understand that we're talking about this subsection of an overall tax when this is the term that's been used? And again, in your briefs, you never describe it as that. The only time that you use the term transaction privilege and use tax is when you're quoting it from something.
Right. Well, again, if you read the tagline, I'll just use the tagline for example, okay? If you read the tagline, people who live in Scottsdale, we start with the premise that these voters are presumed to know the law, okay? These voters know when they buy something, this is what the sales tax is. They know it's not 0.20, okay? They know
Do they really know that that's what the sales tax is? Or
on
your receipt, I assume that it says 8% or whatever
I don't even live in
is.
Scottsdale, and I know, because I shop in Scottsdale. I do look at my receipt. I do know what I'm charged.
And it says 0.2%.
No, it would be the sales tax rate, whatever their transaction privilege tax allows them to charge, whatever that rate is.
But the receipt would add the state sales tax.
Correct.
And it would say 8%, for example. It wouldn't say
for example,
1.7.
right. It's not, no receipt is going to say, and 2% is used for the Sonoran Preserve. Of course not. But the voters know what they passed in the 90s, and they can read this and know what they have the opportunity to pass here. They really can. And honestly, this label is irrelevant if you think about it, okay? Because all that matters is that we're telling voters what the options are, what they're voting for. And can a reasonable person understand that? And I would submit to you, by the way, to answer that question, you're the reasonable person. I'm the reasonable person. It's an objective person who can read and comprehend the English language.
And I appreciate what you're saying there, but in communicating with the voters, what this actually does, if you look at the no language just says you're not voting yes. Quite frankly, what the no language could say is that the tax terminates, and that's what a no vote is. So, are we really being clear to voters?
Yes, I believe we are. Because it says right here, no vote shall have the effect of denying the city the authority to replace and reduce the current .20 transaction privilege and use tax rate expiring in 2025. Look, I agree with you, there are lots of ways to say this. But we're not here to quibble about the best way to say it. In fact, our courts have told us that's not our job.
Right, but the court in quality education, the no language was, this results in no tax.
Understood.
It was a very short statement for the no language. So I guess my question is why do you even need all the other language if the courts have already said this is acceptable?
Well, I can give you, there's a legal answer, it's a practical answer.
Okay.
All right, I think the legal answer is it doesn't matter. As long as you can read this and an objective, reasonable person knows what it means, it doesn't matter. I think the practical answer is, honestly, the city just wanted to get it right. They want to tell voters what that means.
But if the court already told you what was right, then why would you use any other language?
Well, again, I think the quality education Bennett case, it was right there. And I agree that that was right there. I agree it could be right here too. But this isn't wrong. And really, that's the question, isn't it? Is looking at this, is this wrong? And I don't think it is. The Superior Court didn't think it is. And I don't think it is.
But how does that accurately reflect what a no vote will do? When you're just saying a no vote, it means you're not voting yes.
But it doesn't really, I disagree. I respectfully, obviously.
Sure.
I disagree. I think when I read this, okay, I read it as saying, I know what the yes vote says. The no vote says you're not doing any of that. You're not doing that. And that right here, expiring in 2025. It's clear to me, at least as reading it, that if I vote no, that expiring in 2025 is going to happen. I agree that there's a lot of wording there. I just don't think it's objectively false, objectively misleading. I think it conveys the thrust of what they're asking voters to do. And in this case, they made an analogy in the Superior Court, the plaintiffs did, about a contract. And they said, we have a contract with the city, and this is a bait and switch. Really, that's a great analogy. This is just like a contract in that we have a deal. Right now, that deal says in 2025, our deal expires. We're simply going back to the people and saying, hey, what about this deal? And you can agree, and then we can do all these things. Or you can say no, and we won't do any of these things, and it'll expire. There's nothing wrong with that. Nothing at all. And I don't think that we need to really dive into the best way. I think it's dangerous to dive in the best way for the city of Scottsdale or any municipality in the state to word something, because we're always going to have that disagreement. I think we really need to step back and focus on, is this language here, even if we don't like it, objectively false or misleading? To quote Malera, does it obfuscate the thrust of what we're trying to accomplish here? And I submit, when you read this, you understood what it meant. And I think a reasonable objective voter will too.
I'm not sure I understood that it would drop by 0.2% if they voted no.
It won't, if they vote no, it goes away. It expires because the rate is expiring. It says it right here.
Right, but it says you don't give us the power to reduce.
It says, just look at the tagline too.
If I'm an average voter, I think that means it increases somehow.
Well,
here's what the city said in the Q&A document. What happens if this ballot proposal is rejected? If the voters reject this ballot proposal, the 0.20% McDowell-Sonoran Preserve tax will expire June 30th, 2025. The city sales tax rate will be reduced from 1.75% to 1.55%. I appreciate the city providing that explanation in the Q&A document, but I'm not sure why that doesn't somehow need to be reflected in the no response on the ballot.
First off, I would submit that you want to read what's going to be on the ballot in its entire context, right? You're going to have the tagline, the yes and the no, right? If you look at the tagline, assuming the voter's going to start at the bottom to the top, and I would submit that an objective, reasonable person would. You're going to read it. Shall Scottsdale's current .20 transaction privilege and use tax rate expiring June 30th, 2025 be replaced and reduced to 0.15? It says that in the tagline. Again, I will not sit here and tell you that what you propose isn't a good proposal. I'm just telling you that what's here in the context of this is fine. It may not be the best, but it's good enough. It's legally sufficient.
How is this not a new tax?
Well, the reason it's not a new tax is because the tax code's not, the tax itself is there. There is a transaction privilege tax. It is a tax. Well, first I would say it's irrelevant to your analysis, but putting that aside, it's a tax rate. It's a rate. That's it. It's part of the tax. This rate goes away. That transaction privilege and use tax exists. It's still there. It's lower, but that tax exists. This is not a tax. We're asking the voters, we're saying, hey, that piece of this tax, that rate back in the 90s that you passed, we'd like to extend it this way and for this reason, which, by the way, to answer your question earlier, because I know you asked it, is there overlap between the two? Yes. In fact, he admitted it before he sat down. He sat there and told you guys, he said, just told the panel, he said, looking at the description in 95, he said to you guys, or looking at the description here, he said, it says they're going to use it to upkeep and maintain. Surely they've been doing that all this time. Well, yeah, because we had permission to do it then. Because in 95, if you look at the index of record at 39 and 40, I submitted the 1995 proposition, and it was passed, quote, for the purpose of maintaining scenic views, preserving plant and wildlife, and supporting the city's largest industry tourism while providing public access and passive outdoor recreational opportunities for residents and visitors. There's plenty of substantial overlap between what's happening.
Right, that's talking about the purpose of acquiring the property in the Sonoran Preserve.
That was part of it then.
My understanding is that upkeep for the Sonoran Preserve, park rangers, all that comes out of the general fund, is separately funded from the 0.20% tax, which is for acquiring property.
The 0.20% tax was also, though, from what I read you, again, it's in IR 39 and 40. If you go to page 4, Prop 400, May 23rd, 1995, it was also passed for the purpose of maintaining scenic views, preserving plant and wildlife, and supporting the city's largest industry tourism while providing public access and passive outdoor recreational opportunities for residents and visitors. So it wasn't just to acquire it. But moreover, it doesn't matter, because the question here is, what are you asking the voters to do, and do they understand what they're voting yes or no for? That's fine. Again, I liken it to their contract analogy below. It's no different than you and me cutting a deal, and then before it's set to expire, me coming to you and saying, hey, well, what about this deal now? You can agree or not. And that's exactly why we have referenda. That's what they're for. The government is going to the people and saying, here's an idea, what do you think? Tell us.
Okay, so 17% of the funds from this the proposed tax will be used for preserving maintenance upkeep on the preserve. What else makes this an overlapping tax increase or tax proposal?
I don't think it's a tax increase. Again, the overlap is that it's just, I think it's the same language in both. It's what I read you earlier. I don't want to read it again, but thank you. It's that same language. I mean, I think it's literally contained, if not word for word, pretty darn close in both. And I think that in and of itself would be sufficient if overlap mattered. And again, I don't know that it does. I don't believe it does.
The city said on page 1 of the Q&A document, the replacement tax would take effect when the expiring tax terminates. There would be no overlap.
Yeah, I don't know what the Q&A document, as far as if that reflects the current version or not. It may be the version in the record. I do know that the city continues to supplement and update the Q&A document, and has as recently as after this case was filed. My answer to that, though, would be that the Q&A document isn't what this court needs to review. That issue is what the Q&A document says or doesn't say is not before the court.
Yeah, but doesn't the Q&A document sort of speak to whether the language is misleading or not? Because if you're saying something different in the Q&A document than the plain language of the proposition is, I mean, doesn't that speak to the fact that it's misleading?
I don't think the Q&A document here is misleading, though. I think even...
That's not what I'm saying.
Okay.
I'm saying that if the question is whether the ballot language is misleading, then we have the Q&A document that says something else rather than the plain language of the ballot proposition, which is what we're looking at. You're
Right.
absolutely correct. But if that's describing things that are happening, that is very different the way it's described than the language in the proposition. Doesn't that speak to the fact that this is potentially misleading?
I don't believe so because, again, the Q&A document, until it goes to print, I think the Q&A document's a version of it will be included with the ballot, I believe. But I think at the end of the day, the Q&A document is subject to change unless and until, things go to print. So, for example, I can tell you that Q&A document that was in the record below, it's changed since the last time that the court saw it. And it may change again in an effort to make things as clear and transparent as possible. I think, along with Mr. Dave Freeman, I would agree
But
that
shouldn't the language on the ballot be as clear and transparent as possible?
I think that the language on the ballot only needs to not objectively reflect falsity. It can't be objectively misleading, and it cannot confuse voters. I think that's the standard. I get what you're saying, but it also assumes that every objective, reasonable person is going to read the Q&A document. I don't know that that's the case. I mean, Judge Catlett said he didn't. I don't know that I do. When I vote, I won't say I never have, but I can't remember ever reading one whenever I voted on the proposition.
So in quality education, you had a similar situation to what you have here. You had a temporary sales tax that was set to expire, and you had then a permanent 1% sales tax that was going to be enacted. And the ballot language said that was a tax increase. The court said that wasn't objectively false and misleading. I'm concerned we're walking into a situation where if we saying reduce also isn't objectively false or misleading, we're setting up a scenario where increase or decrease is in the eyes of the beholder and whoever's drafting the ballot language, and depends on whether they want the thing to pass or not.
I don't know that I agree with that. I don't think it's fair, especially on this record, to infer, at least here on these facts, that the city of Scottsdale was advocating one way or the other here. I think the record, it's fair to infer that they were doing what they thought was the right thing, their best job. And just to return to a question earlier kind of related to that, I mean,
The council passed the resolution. It wants
Correct.
It wants this to pass.
Agreed.
Right.
Well, no, it wants it to go to the voters. We all know how councils work. I can't tell you, as I see it, I don't think it's in the record, how many of the members of the council were in favor of this, how many weren't. For all we know, there was they all could have been for it.
I mean, the minutes reflect it was 5-2.
So there you have it. So if the minutes reflect it was 5-2, then we know not everybody in the council necessarily wanted it to go to the voters. So I don't think it's fair to say that.
Well, but can we even say that? I mean, some of them may not have agreed with the language, and therefore it was a problem. It wasn't that they didn't want it to go to the voters, it's that they didn't want the language to go to the voters.
I cannot tell you that's not the case any more than I can tell you that it is. But I can tell you that luckily, for your purposes, you don't have to dig that deep. Really, it's a facial review of what the proposition says. And I think it's important to remember, too, back to your point about the rate. Remember, the rate itself, it doesn't overlap, right? There's no gap either, because it either goes away when it expires or it continues, right, at the reduced rate. Where there's overlap is the dedicated purpose here, right? And the dedicated purpose overlap is it's still going to be used with respect to promoting that tourism, et cetera, and so on, and the other things that are listed there. And it's not completely unrelated to what was passed in 1995.
So Tobin v. Rea was the companion case to quality education. Quality education dealt with the ballot language, as we've been discussing. Tobin v. Rea dealt with the language that was in Ledge Council's analysis that was going to go along with the publicity pamphlet. And so it dealt with the same situation of the temporary sales tax expiring on one day and a permanent sales tax being proposed that would go into effect the next day. I think here it was May 31st of 2013 versus June 1st of 2013. In paragraph 17 in Tobin, the Supreme Court said, under current law, the state sales tax rate on most business classifications will be 5.6% of the tax base on June 1, 13. meaning it would go from 6.6 to 5.6 because the temporary sales tax was expiring. It was a 1% sales tax, it was 6.6, but because that was going to expire on June 1, under the current law, it would go down to 5.6. The court said the initiative would impose an additional 1% tax from that date forward to raise the rate to 6.6%. Contrary to the Superior Court's statement, Prop 204 would not, quote, continue a temporary tax that would otherwise expire. Rather, the initiative proposes statutory changes that would impose a new, permanent, and legislatively unalterable tax, the revenues of which would be directed to different and broader uses than those under the current constitutionally imposed temporary tax. How do we not have that same situation here? Seems to me like the city is trying to say the same thing as what the Superior Court said in Tobin, and our Supreme Court said, no, that's not the right way to look at this. Under current law, the 0.2% tax goes away, and then the rate is increased by 0.15%.
A couple answers to that, a few. Number one, respectfully again, I don't think Tobin is necessarily comparable. The legislative description, that is expressly excluded under 19141A, right? So we're not dealing with that. We're not dealing with having to do it the way that the legislature is supposed to do it. That's number one. Number two, all that matters here is if you read what is in the proposition. Is it objectively misleading? Is it objectively false? Does it fail to convey the thrust of what the proposition is asking the voters to consider? And again, the answer is no. No, it's perfectly fine. It may not be the best. It may not be the way you would have written it. Plaintiff's counsel doesn't know how he would write it. But the bottom line is we got to look at this by itself and make that determination. And I don't think it's fair to infer the example that was used in Tobin in connection with the legislative Q&A and then transpose that over into a situation where you're dealing with the actual referendum. In my opinion. That doesn't count. Are there any other questions? I've got 26 seconds. I'm happy to use it, but I want to make sure I answer your
I had
question.
the question about how were the funds segregated?
Yeah, my understanding, this was discussed at oral argument. I don't think it's in the record because they didn't order a transcript. But yes, my understanding is that the funds are segregated into their own place so they can be used for the purposes for which they're supposed to be used.
Well, I mean, the funds that were used to acquire.
Correct.
Okay.
I think we're talking about the same
Is
thing.
that just an accounting entry, or is there a separate?
Oh, that I
We
don't know. My understanding is a very general that 0.2%, that money is taken out and it's in its own place.
Right, but it's not in the general fund.
I don't think so, but I don't know for sure.
There's no doubt these funds just go into the general fund,
I don't know.
the 0.15%.
Oh, I'm sorry, with the new rate?
The funds raised by the 0.15%, if it's approved, those are general fund.
I don't know. Yes, the answer is yes.
Okay.
The city attorney says yes.
Okay.
Thank you.
Thank you.
Just want to hit a couple things that council mentioned. First, with respect to the 95 tax. Our reply brief quotes the ballot provision in its entirety. It's to buy land. You look at the yes-no consequences. A yes note shall have the effect of authorizing the city council to increase the sales tax for 30 years for the purpose of acquiring land for the McDowell Sonoran Preserve, period. A no vote doesn't let you raise money to acquire land. The notion of the purpose of, it's for the purpose of maintaining scenic views, preserving plant and wildlife, and supporting our largest industry, tourism.
Right, the
That's a
purpose
consequence
of buying land.
of buying desert land and putting it into a preserve. It's not what they're actively spending money on. The only thing they're spending money on is buying the land. That's very different, and there is no overlap, not only temporally or in terms of subject matter, with the new tax that they're opposing.
Do you know whether for the last 29 years, funds needed for upkeep or park rangers and things like that came out of the general fund or out of the funds raised under that prior proposition?
I don't know whether the city abided by the 95 tax and strictly used it for those purposes. I don't know that. But I do know, have
It
interest.
looks to me, based on the presentation that was given to the council, that the general fund is used to hire park rangers and things like that, and that's what these additional funds might, so for example, they have 3 full-time employees that are park rangers, and they're proposing this might take it to 4.
Right. So they want to, that's a question they could put to the voters. We want to raise additional revenue because we want to augment funding. We want to increase funding for maintenance, improvement, and police and fire. Not just increase with respect to police and fire. So yeah, for the last 29 years, I think we've probably all driven through Scottsdale and the grass is green and somebody's mowing it. They're spending money, they're raising money and they're spending on those things. They want to do additional things. That's fine, that's okay, but they got to bring it to the voters in a non-misleading way. With respect to the fractional tax rate used throughout their briefing, that's an attempted dodge. Voters don't pay an abstract rate. Voters pay taxes. Or citizens or people who buy things pay taxes. They don't pay an abstract rate. Every sales tax has a rate associated with it. The rate is simply how we measure the amount of tax that will be raised. So whether you call it a rate, whether you call it a tax, whether you call it a sales tax or a sales tax rate, it's all the same thing here. But it's the city's way to try to obscure the fact that there is a new tax being imposed. In fact, they boldly say in their answering brief, there is no new tax. There is a new tax. Most definitely there's a new tax. A 0.15% tax that will be imposed on a certain date for certain dedicated purposes. That's a new tax. Here let's see.
I mean,
The-
as council points out, the no language does say that the current rate is expiring.
It does, but everything in the tagline and everything else only references a reduction in the context of passage. If you vote no, it won't allow us to replace and reduce the tax. That is inherently misleading. They couldn't even say it in the no language, that if you vote no, the status quo will be in effect, which means the 0.2% tax ends and your taxes go down by that much, which is a 300% greater decrease in the tax rate than if you were to pass this new measure. That's a pretty big difference, and it's something they should have been playing with the voters on. The whole, I guess lastly is we brought this case to try to bring integrity to the election process, to make sure municipalities play straight with the voters, not try to engage in a sales pitch and convince them that they're getting some sort of break or they're not paying any new taxes when they actually are. And we did it in an accelerated fashion to give the city a chance to fix it. And they could have. They could have even as late as last month. They did not. They've held to their guns. So the only option we have now is for this court to disqualify it and send them back to the drawing board at some time in the future. And I'm out of time.
Thank you. Council, thank you for your presentation today. We appreciate your briefing. We'll take this matter under advisement and issue a written decision in an expedited fashion. Court is adjourned. Thank you.
Thank you.